we go to the first slide here with the powers of attorney for property, just as a broad, so the next slide there, if we start with just a general sort of, I guess, definition, what a power of attorney is a grantor, being the person who's giving the power of attorney. It's a legal document that you would sign to allow someone else that you trust to have the authority to manage your money and your property on your behalf. So sometimes we get questions like, does that have to be a lawyer? Does it have to be someone that's, perhaps an institution? And it doesn't have to be that way. It can be someone who it could be someone you're related to. It could be a friend, just anyone that's someone that you trust. Importantly, there is a difference, and this, I would say, comes on the lawyer's desk quite often. Sometimes realtors may not pick up on it, or even clients in some cases, but there is a difference between a power of attorney for property and a power of attorney for personal care. So your power of attorney for personal care allows your power of attorney to make healthcare decisions on your behalf. Perhaps you're in an emergency situation. They can instruct your medical person, your doctor, to make healthcare decisions for you. It's very different from a power of attorney for property, who can only manage your finances and your real property. So there is a very big difference. So if you come to the office with a power of attorney for personal care, hoping that we can help you or assist in the sale of a property, that's no good. So it has to be a power of attorney for property. Cal, would you add anything to that?
No, I wouldn't. I'll defer to your good judgment.
Moving on then, so there are types of powers of attorney for property themselves. So one is a general power of attorney. So this would be while you're still maybe mentally capable of managing your own affairs or taking care of your property, but this is something that we see used quite often with perhaps you're leaving the country and you want to allow someone to deal with the sale of the property while you're gone. In that case, you're going to need to have a general power of attorney. A specific or limited power of attorney is a little bit different. This one, that's a type of general power of attorney, and that way you can give them a limited task, or you can give them a general one, but it's not valid once you're incapable. Whereas an enduring or continuing power of attorney is something that survives the point where you become incapable. So you'll see two different powers of attorney being used for a sale depending on the circumstances of your particular situation. So it is important to speak with a lawyer on that front and confirm which document it is you need. And as a realtor, I would confirm that they have the right document. It would be really bad if you came with a general power of attorney that was only for dealing with a specific property for a specific period of time, for a third property, or something outside of the authorized period of time. So it's good to consult a lawyer prior to showing up with those documents. Okay. Next, what can my attorney do? So, Cal, go ahead. I feel like I'm talking too much here.
Well, the power of attorney, of course, unless you limit the power of attorney, can do just about anything. One of the things I would suggest to agents who encounter somebody using a power of attorney is to ask some questions in general about the background, who the owner of the property is, of course, and what their situation is. Are they in a nursing home? Do they have their full capacity? Are there any brothers and sisters? And sometimes you may get a signal that there could be possible problems, and it's a good idea to try to recognize that as early as possible in the process, sort of thing, so that you don't wind up wasting your time because somebody signs an offer under power of attorney and one of the children pops up with a lawsuit or something of that nature. So it is a good idea to ask some questions around the owner of the property and the state of mind that they may be in, and whether they're in an institution, and whether or not all the brothers and sisters that there may be are on board with everything. And that's probably more important than anything, I think, to try to anticipate a possible problem.
Yeah. And I would probably just add, I've had a client in the past ask if they can use the power of attorney to purchase a property for a parent, just sort of switching from like maybe a 2-story home to a bungalow, because that's more, that's something that would help the parent be more mobile in their own home. Now you can do that, but, and there's a big but there, this particular client wanted to mortgage the property. Now you cannot buy a property or mortgage a property with a power of attorney. So, so that's a big no-no. So before entering into an agreement of purchase and sale, that might be something you may want to canvass. Of course, if they're relying on a mortgage for the property, that it just can't happen. Yeah.
Yeah, good point.
Yeah. So, anything you want to add to that?
No, I don't think so. You go ahead.
So the next slide there says, who is the executor? So quite often, I think clients do sometimes confuse a power of attorney with an executor. And quite simply, your power of attorney is someone that has the authority to deal with your affairs while you're alive. The executor does not kick in until you kind of kick the bucket. So it doesn't, it's the person named in your will to carry out the wishes and directions that are listed in the will. So that's a little bit different. So once you're deceased and there's an estate sale, it's a little bit different than while the power of attorney sale is happening, because that all would have happened while the owner was still alive. This is what, now they're gone, and the estate trustee or the executor or the representative or the executrix or the administrator, they're all used interchangeably. They just define the same person at a different stage of the administration of the estate. So the executor will be the one to sign that agreement of purchase and sale once that person is deceased. Right?
Yes.
So Cal will talk to you about the role of the executor in real estate transactions.
Well, the big thing, I think, with the role of the executor is to make sure that they've been properly appointed to the court system. And of course, this is where the possible delays will incur. In other words, don't have the executor signing an agreement or a listing agreement or anything like that before they get official approval by the court system. And you have to bear in mind, as Sarah indicated, that once people have passed, the power of attorney no longer is appropriate to use. And so you have to wait for the court to officially name the power of attorney or multiple powers of attorney.
That's right. Yeah. So the just to add to that then, so the role of the executor doesn't really become, for real estate purposes, of course, doesn't become official until they have that certificate of appointment to be the estate trustee. Until then, it's simply the wish of the deceased for that person to be appointed. But without that certificate, they don't have any real authority to deal with a property. They just can't register a transfer without that. So while they have authority under the will, they don't have a registrable authority, I guess, so to speak. So so it is important to make sure that if you have an executor who hasn't went through the probate process yet, to reach out to a lawyer and get that certificate of appointment as soon as possible. We can probably combined tell you many horror stories of probate applications not being processed in time, or executors not getting their probate certificates, and delaying the closing of a real estate transaction. So it is absolutely imperative to have that in place.
One of the things, we had a recent case, this involved a friend of ours that passed away, but prior to her passing, she was sick in the hospital, and her children are acting as powers of attorney, and an offer did get executed. And unfortunately, she passed before the closing date, and that sort of delayed the official closing, because then the whole process had to go through the court system. And I think in her particular case, it probably took about 3 months. I don't know if you remember that one.
Yeah, that's right. Yeah.
Before the deal finally got closed. So
Yeah.
don't spend the commission.
All right, so that takes us to the next slide on the probate process. So when someone dies, it's the executor's job. First things first, they'll take care of obviously all the funeral arrangements and all the funeral expenses and all of that. Then their work really starts, where they have to start collecting all the information with regard to the assets of that estate. So whether it be real property, personal belongings, any other assets, bank accounts, all of that, that will have to be brought to a lawyer. You'll need the original will, if there is a will. You'll need the death certificate and all of this information. So what we do here is we will canvass all of that, calculate your probate taxes, file the application with the court, and then the rest of it is really waiting for the court to approve the application, really. But really, that is an imperative step. You don't want to overpay, the taxes are underpaid, but most importantly, you can't deal with the house until we've gotten that certificate. So starting the probate process as early as possible is highly recommended. And then we can get into how long it takes.
And one of the complications nowadays with the COVID thing is to just simply get proper statements from financial institutions can really be slow.
Yes.
Just to gather the information, let alone file a probate and let the court systems go through it and finally get a judge to sign the order. So the whole process has been slowed down by the COVID virus.
That's right. Yeah. So the process itself is not very difficult unless you've got a very complicated estate, many properties, lots of mortgages, that sort of thing. But it is really just more of an information gathering task for the executor, and then we sort of dissect it here and advise accordingly. So in the next slide, we talk a little bit about how long does it take to draft and file a probate application. So we recognize that these things are time sensitive, especially when you've got an agreement of purchase and sale with a closing date in place. One of the things that I think I would advise every realtor when you're drafting an estate sale agreement of purchase and sale is ensure that you have extension provisions or clauses in the agreement, because probate doesn't always get processed as quickly as you'd hoped. Even the date that you thought was a well enough contingency that you're sure to get it by this date, you really just don't know how quickly it can get before a judge and how quickly they'll be stamping it and returning it to your lawyer. So I would say that, of course, the information gathering portion is up to the client. That can take however long it takes the client to get that done. As far as us preparing the application and submitting it to the court, that's probably the quickest step out of the 3 steps. And the last step being the step where the court is actually reviewing and kind of assessing the application itself. That matter is completely out of our hands. When there is a real estate transaction, we do advise the court that there's a real estate transaction pending. That sometimes does kind of put some fire under their heels, and they try to get it back in time for closing, but it's not a promise. And unfortunately, judges don't like it when lawyers tell them what to do and how quickly to do it. So, so there's no guarantee. And especially with COVID, things are just moving at a snail's pace. So having that clause in there, just saying that there's a mutual extension of X amount of days, or maybe a number of extensions, until a probate certificate is obtained, is very wise. Want to talk about the last one?
I think we've covered the
Yeah, I think
time
we've
frame.
covered that time frame. Yeah.
It's basically ambiguous. And the key thing, I think, is that when you're dealing with a situation where there's a power of attorney, going back to that subject, to ask questions and as to the state of the person, whether they're in the hospital, how serious is it, and so on and so forth. And perhaps that relates to what Sarah says in terms of perhaps planning extensions. If the person is close to death in the hospital, you have to anticipate that there could be some delays down the road.
Yeah.
And then, of course, there's always the issue of, is the power of attorney or powers of attorney the ones that, I mean, so often you run into difficulties with the family fighting, and some member of the family accuses the other of unduly obtaining the power of attorney. And
That's right. Yeah.
all kinds of situations like that. So it's just a sign of taking a little more caution and asking questions when you run into it.
Yeah, I would agree. And I'd like to share, just recently I had this situation where there was a probate certificate that we were waiting for, and the court took, I want to say, 3 months with it, which is, if you look at the last slide, we've said it takes about 6 to 8 weeks. And I think that would be a pre-COVID for sure, and a very light caseload at the court sort of time frame. But in this instance, we had the clients decide, without consulting the lawyer or without consulting us, that they were going to enter into an occupancy agreement with the purchasers in case that the probate certificate didn't arrive by the closing date. And that was fine after 2 months, and they did that, and they mutually agreed to a lease amount, and both parties were happy. But it was a 30-day lease upon which it was null and void, and 30 days passes and there's still no probate. So on this now closing date, the extended closing date and the end of the lease, the lawyer on the other side says, if you want to re-enter into a lease agreement, we're only prepared to pay about $500 less than what you initially agreed to. Now, of course, the clients, the sellers or the estate trustees, were not happy with that at all. But in my opinion, I don't think a lease agreement should have been, or an occupancy agreement should have been entered into. And then if they said, no, we won't, we're not closing, and off you go, then there would have been a breach. And then of course the purchasers are already in the property. It was just a mess. So it is really important to have those extension clauses in the agreement. And also I would say to speak with your clients and maybe let them know that maybe an occupancy agreement should be discussed with a lawyer prior to drafting one for your client, and having them enter into a lease agreement, especially with COVID now, I'd say, because landlord-tenant board is closed. So you may have created a situation where now it's not a seller and purchaser relationship, but one of a landlord-tenant, and with evictions off the table, they may be stuck with having someone in the property without having to pay rent, and it just really creates a big mess, and I would advise against it. So I think unless there's some questions, we can certainly answer those. I don't know how to.
Can anybody hear us?
Yeah, there's actually been quite a few questions just while you've been talking. So one person was asking how they can verify the authenticity of a power of attorney.
Well,
Well, one of the well, I shouldn't say most often, but probably most often, powers of attorney are executed at a lawyer's office, and you can confirm with the law firm that they in fact were witnesses to it. When it's been signed by other witnesses other than a lawyer, it would perhaps indicate that maybe more questions should be asked, and perhaps speaking to at least one of the witnesses to just confirm that there's no fraud involved or anything like that. But I mean, you have to, obviously you're not going to suggest that, but
right.
It is to make sure that the person is using the power of attorney properly.
Right. And I would say it's also important, even though you would think that this is sort of goes without saying, but it has to be an original document. So I have had clients in the past who have, went through their parents' belongings and found photocopies, and no original. Unfortunately, without the original, there's nothing we can do. So it has to be an original document.
Excellent.
And the next question was, what's the order of priority when there are numerous powers of attorney found?
Yeah. So if there are numerous, it's the most recently dated one. So anything that's signed after technically is the newest one, and it should void the others. I would always advise clients that when they are executing a new one, to bring in the old one so that we can appropriately destroy it here before they sign a new one. But it is the newest one. That's the most valid one. So of course that could create some problems. If there were 4 of them signed in a span of, let's say, 6 months, I think that would raise some questions that require some further, yeah.
Great. And what are the liabilities of an executor?
Yep. So,
well,
where do we start?
Depends on how many brothers and sisters they have who are going to sue them.
So an executor it is a job, and they do have a fiduciary duty to the estate. So there is a personal liability when an executor takes on that job, much as if any other agent was taking on any agent-related sort of job. So if an executor should be keeping all records of their the ins and outs of the estate, everything they've done, because if you don't, and let's say it does go to court, if it is litigated, and they find that an executor didn't do their job appropriately, it can have some consequences for the executor. That's why there's executor fees, because it really is a job and you can be paid for it. So depending on the, yeah.
Okay. And go ahead with the next question, Jennifer.
Is it a good idea to retain a copy of the will and death certificate to add to the listing or sale paperwork when you are representing an estate?
I would say yes.
You would say yes?
Well,
I would say no, only because the purchaser has no right to see what's in the will. It's the executor's job to deal with it or dispose of the property in the agreement of purchase and sale.
Yeah, okay, I misunderstood. Yeah, no, I don't think that's necessary.
No. Or even when we're listing the property, would you suggest having those documents in our files when we're representing the estate listing properties, or would just a simple direction from the lawyers and the executor be enough?
Yeah, I think if you wanted the death certificate for your records, now it's not something that I would post or make public anywhere, for sure. But if you wanted to keep a copy of the death certificate in your personal file for your viewing, that should be fine. The will, I don't think you still need.
No.
Yeah. So the death certificate if you really want to make sure that that person's gone. And but other than that, I'd say no. You're welcome to take a look at the will to make sure that the executor is the one, but really, I wouldn't. Right? I mean, I wouldn't.
And you mentioned potential extension clauses or multiple extensions in an agreement of purchase and sale. Is there anything else that you would like to see in an agreement of purchase and sale with regards to an estate sale?
What do you think?
Nothing off the top of my head, but that doesn't mean anything at my age. But
I would say things like the warranties that you provide as an executor. Be careful, because if you haven't lived in that property and it's been, your mother or your father's property for maybe 20 or 30 odd years, you don't want to be warranting anything without direct knowledge of whether those things should be warranted or not. So we see a lot of estate sales with as is, where is sort of clauses in it. And I think that's appropriate for the realtors that do that, because you really can't be swearing to the quality or to the, or warranting anything in the property when you haven't lived in it. You don't really have any direct knowledge.
All right, Jennifer, go ahead.
Oh, sorry.
There's a clarifying whether a power of attorney has the ability to list a property but does not have the authority to purchase property if there is a mortgage. They only have the authority to purchase property if there isn't a mortgage.
Looking for clarification there.
Yeah.
Okay. So, I mean, we've never really, I don't want to say we never really seen it. We have seen powers of attorney purchasing a property. Let's say that maybe they don't need to go into a home, but they should go into whatever property. Again, this is something you should speak to your lawyer about before purchasing any property as a power of attorney. Speak to the lawyer, because a lawyer does have to see the will itself and really determine what the wishes of that person, like what they are. It's really important. So it's very rare that you see someone purchasing a property. You definitely cannot do it if there's a mortgage. You may be able to do it. Let's say they've got X amount of dollars and this is for them to live in, the house is going in their name. I believe you can do that, right?
yes.
It's, but selling, yes, you can do. The other one we see a lot of, I want to touch base on this one, is selling to yourself as the power of attorney. Power of attorney for your parent, selling the property to yourself. That raises many red flags, and there are a host of considerations before a lawyer would let somebody do that. So that's another thing to add to that list of that requires some further discussion.
Okay, good to know. And
Or the other members of the family.
Yeah, or the other members of the family who may not like that. Yeah.
Of course. Also, can the executor be a beneficiary?
Yes.
Yes.
Yes, absolutely. That's
Okay.
probably the best scenario. If you're one executor and one beneficiary,
Yes.
there's no one asking you what you
All right, Jennifer, do you see anything else in there?
But there's one question about a specific clause, and I think that clauses themselves should be individually reviewed, in my opinion. So I think that may be something that needs to be directed at a specific lawyer, when we're talking about a very, very specific clause that somebody's putting in there. So
Sure. Yeah. If you have any specific clauses you'd like us to take a look at, you can certainly shoot either one of us an email, and we'd be happy to take a look at it for you. Or if you have any specific questions with anything that today, certainly feel free to reach out to us. We'd be happy to answer any very specific questions. It's hard sometimes to give broad brush answers to very circumstance or situation specific.
Well, thank you very, very much again, Sarah and Cal. So nice to have you on as our guest speakers today.
I like your glasses, by the way.
Oh, thank you. Thank you.
I don't think I've ever seen those before. Are they brand new?
You're funny. So we will sign off now. Thank you everyone for joining us once again on Mindset Monday. Thank you, Sarah. Thank you, Cal. Have a great week, everyone. And we'll take care. We'll talk to you soon.
Thank you, everyone.
Bye.
Take care.
Bye.
Bye-bye.